Mr. Harty.
Your Honor, may it please the Court, Frank Harty for the Appellants. The Court today is faced with one question, and that is, does the Iowa Civil Rights Act apply to a workplace on the other side of the world? The appellants assert that the Iowa Civil Rights Act does not apply to someone who lives and works in China pursuant to a Chinese employment agreement. The appellant in this case lived and worked in China. Therefore, the law does not apply. We've got a very robust recitation of the facts in our briefing. I'm not going to go through it, but I do want to address a couple of issues that were included in the Appellee's briefing concerning our factual statement. There's contention that the appellant included salacious facts in an attempt to vilify the plaintiff in this case. We included only facts that were important for this court to determine where the employment occurred and where the conduct that resulted in the employment action occurred.
All right, let's cut into what I see as the issue at least, and I think the briefing did present a fair amount of facts and context as required. But isn't this rather similar to a conflicts of law question? I mean, we get them all the time in automobile accidents, and somebody gets injured in North Carolina and was a resident, blah blah blah, and we engage in kind of an interest analysis, and some would say it's a little bit unprincipled, the conflicts of law area, but it's a multi-factored approach. Why isn't that the legal standard that we ought to use in deciding this issue?
Because, Your Honor, in short, because it's not a conflict of law question. It's not a jurisdictional question. The issue, as cited by the appellee, is what I believe got the district court down the wrong path, and that was, they ask is, does the Iowa Civil Rights Act apply to an Iowa resident who is the victim of discrimination by Iowa defendants for conduct that occurred in Iowa? That's simply not the case. The issue here is, did the Iowa legislature intend the Iowa Civil Rights Act, when it was drafted, to apply halfway across the world when someone is living and working in a foreign country? And we submit, Your Honors, that this is not a jurisdictional question. Deere is subject to suit.
It's not. Right. That could be. But frankly, it's a little hard for me to gather that the legislature had any specific intent on the issue. Obviously, they want the Civil Rights Act to be robust. And I also would agree with you in that obviously there's limits of some kind. But I guess I'm having trouble developing anything other than a multi-factored approach to whether or not the Iowa Civil Rights Act should apply in this particular case. I'm not convinced as yet, and I offer you the opportunity to convince me, of course, but I'm not convinced as yet that there's some kind of bright line rule lurking that the legislature must have intended. So help me out. You understand the nature of my concern?
Sure, Your Honor. Yeah. Let me submit to you that where you're struggling in the area of the law, you've gotten past the presumption. The presumption that has been the legal presumption in this state for nearly a century is that unless the legislature clearly states that this law is going to have extraterritorial application, the presumption is it does not. The Iowa Civil Rights Act contains nothing that would indicate that it was the legislature's intent that it apply beyond the boundaries of the state. To the contrary, the statute itself.
Well, I mean, you're right. I mean, there's nothing expressed, but we have border problems all the time. Less, I mean, not in China, but in the Quad Cities or Sioux City, Dubuque, East Dubuque, all that kind of stuff. The mere fact that someone is an Illinois resident is not likely to disqualify them from coverage under the Iowa Civil Rights Act if there's an Iowa employer and an Iowa employment contract.
Let me take a Quad Cities example. That's the example I want to work through. Deere's international headquarters is in Moline, Illinois. And that is where the individual defendants in this case, contrary to the statements in the Appellee's brief, they didn't work in Iowa. Dr. Haas was the vice president in charge of the global tractor platform in the international headquarters in Moline. Rich Jahnke was in charge of tractors, reported to Dr. Haas, worked at the international headquarters in Moline. Let me take an example. Let's assume that we all know that our laws are different than the laws of other states. One example, we've mentioned several in the briefing, but one example comes to mind, and that is the Iowa Civil Rights Act protects against age discrimination anyone who's 18 years of age or older. Illinois has a civil rights law that protects those who are 40 years of age or older. Let's presume that I am a Deere executive, that I have worked my way up to the international headquarters in Moline by working in the Ankeny Works, Des Moines Works, Ottumwa, Waterloo. And let's say I ultimately want to be back in Des Moines. That's what I consider my home. But I am working now in the international headquarters in Moline, Illinois, and I believe, I'm 39 years old, 39 years old. I believe my supervisor, who also works with me in Moline, discriminated against me because of my age. I clearly cannot sue in Illinois, where I work. I find out that my supervisor lives in Iowa, works in Illinois, but lives in Iowa. So I sue there. Your Honors, Iowa legislature is not so arrogant so as to believe that our statute is so good that it can be imposed and applied worldwide.
Oh, it's not a matter of good or bad. I don't think. It's a matter of ensuring that the public policy that's reflected in the Iowa Civil Rights Act adequately protects employment in Iowa. I surely agree with you that if I was a stranger to an employment relationship, it would not apply, right? I mean, somebody in Florida who's employed in Florida and has no connections to Iowa can't go to district court and say, oh, I've looked at the statutes, I like Iowa, apply it. Of course not. But there's some, I guess I'm coming back, and please redirect me if you want. I mean, there's some factors that I mean, on the surface, it seems like, well, they're way over in China and so forth. That seemed to support your position. Mr. Haas is from Moline, not an Iowa resident, as I understand it.
He's an Iowa resident, Your Honor.
He's an Iowa resident, but
Yes,
he works in Moline.
Moline.
Okay, very good. But, you know, there's factors pointing in both directions, it seems to me. The plaintiff here worked in Iowa for all these years. When he was assigned over there, he was still kind of a reporting relationship to John Deere Ankeny, if I have my facts right, and please correct me if I don't. But I guess I'm saying at the end of the day, there's factors that point in your favor, I think, some of them, and some maybe less so.
We submit that there are no factors that would militate in favor of applying the act in this case, Your Honor. Mr. Jahnke had been in China for over 3 years when the conduct that he complains of occurred. By the time he was demoted, he had shed himself of any home in Iowa. He had no spouse in Iowa because he had gotten a divorce. He had a post office box in Bettendorf, and surely he had spent quite a bit of time working here in Iowa. But to accept that interpretation means that if at some point I come under the protection of the Iowa Civil Rights Act, I carry it with me wherever I go. Even though I have been, at the time this occurred, he was being paid out of Moline as an international employee.
Let me ask this question. If Moline's if John Deere's international headquarters were in Iowa, and the plaintiff was assigned out of Iowa and reported back to Iowa, would it be a different result?
And the plaintiff were in China, Your Honor?
Yes.
Same? Absolutely not. We submit, again, using any of the interpretations of similar laws nationwide. There are 48 states that ascribe to the same presumption that Iowa does, and that is unless the statute very clearly states otherwise, we apply it only to people working within our
So,
boundaries.
understanding your position, is that if you have an Iowa corporation, you have an Iowa employee, you have an Iowa resident who's working for an Iowa company, but it's assigned in another state or another country, Iowa laws afford that person no civil rights protection.
They are afforded the protection of the civil rights of the state that they work in. Under any test that the courts have used, under the center of gravity test or the primary work location test, those are the tests that other states use in determining where someone is working. Under those tests, this is not an individual who's working in Iowa. He didn't pay taxes in Iowa because he didn't earn
So
income.
these companies can send these people abroad where there's no protection, and then fire them because of sex or age or gender or whatever they want to fire them, and not be subject to any liability.
Not true, Your Honor. The Title VII very clearly applies to foreign workplaces. Now, like the other federal laws that explicitly apply to overseas workplaces, Title VII has built into it a provision that is intended to provide comity between the local law and Title VII. That's the Aramco decision by the U.S. Supreme Court. Congress looked at that and said, we don't like that outcome, so they specifically modified, amended the statute to make it apply overseas, and they included a specific application and a provision that says we do not want to interfere with the laws of a foreign company, or country rather. The other laws, the ADA and the ADEA, also apply overseas. They also have that same provision to avoid conflicts. The other federal statutes that don't apply, like the FMLA, the FLSA, the Civil Rights Act of 1866, they don't contain that provision. The Iowa Civil Rights Act refers to, in 216.3, employment in this state. The Civil Rights Act in 216.5 talks about promoting harmony between ethnic groups in this state. There's nothing that indicates that the legislature had the intent to apply the law outside the state. And I submit, Your Honors, that if the court were to do so, that would be a shock to the legislature because, let's take Principal Financial, or any of we have more insurance companies domiciled and found here in Iowa than anywhere in the nation except for Hartford, Connecticut. We attempt to attract them. They're good employers. What the plaintiff's interpretation would do is to say, even though I have employees spread across the country, and they might have at one point worked for us in the home office, but they're heading up our office in Arizona or Florida or California. The fact is, if someone in human resources at Principal passes on or approves an employment decision, what the plaintiff would have you do is, even though that individual has no connection to Iowa, the Iowa Civil Rights Act would apply. That cannot be what the legislature intended, and it's not what the law provides. Your Honors, we submit that for the reasons we've outlined in our brief, both the statutory presumption, the language of the statute, the courts that have dealt with this, including Judge Reed and CRST, and the commission itself. If you look at in our briefing on page 55, we talk about the fact that the commission itself believes it only covers employment that occurs here in Iowa.
You know, I guess I'm not 100% sure what employment in Iowa means, because the employment relationship includes, it seems to me, bosses who direct certain decisions. I mean, the fact that someone might physically be out of the state, and maybe help me here, is it your position that if the work you're doing is physically outside of Iowa, even though your paycheck comes out of Des Moines, and even though you have, you're directly reporting to people in Des Moines, and even though you're selling State Farm insurance, or whatever, but I'm physically doing the work in Omaha, that the Civil Rights Act does not apply?
That's right, Your Honor. It does not apply if I do not work in this state. And everything that this court has done and everything contained in the statute supports that interpretation. Even individual liability. The plaintiff points to the individuals being Iowa, quote-unquote, Iowa defendants. In Vivian versus Madison, this court created individual liability, if I may just briefly conclude, by referring to Iowa Code Section 729, which outlawed discrimination in this state. Everything points to the Iowa Civil Rights Act applying only to employees who are employed in the state of Iowa. Thank you.
Mr. Harty, thank you as well. Ms. Fiedler.
Thank you, Your Honors. May it please the court. Whether issues related to the territorial reach of this statute is framed in terms of conflict of law or in terms of extraterritoriality, most courts in the country analyze them exactly the way Justice Appel indicated was his instinct, and that is by considering which state has the most significant interest in the litigation and in its outcome.
Well, but it's kind of interesting that Iowa does not have a specific provision as do a number of federal statutes. The federal statutes are actually mixed. Some have them, don't, and some don't. But what do we make of that? Do we assume that the Iowa legislature has chosen not to? I mean, they could have cleaned this up and didn't.
I tend to think that you're right, though, in the sense of, did the individual legislators and the legislators in the state of Iowa, did this even occur to them? Especially given how employment has changed over the years. As several people have pointed out, you know, I for one live most of my time in South Carolina now, but I work 100% of the time in Iowa, over the phone and over the internet. A lot of people can do that. When we apply the factors of the most significant relationship test, it is crystal clear that Iowa is the only state and the only place with the most significant relationship.
Well, but he says, you know, employed in this state. I mean, kind of just looking at 4 words. And the argument is, well, your client was not in this state. In a physical sense, that seems right. Why shouldn't we read the in this state narrowly?
Well, number one, the Iowa Civil Rights Act itself insists that it be interpreted broadly. And that is something that this court has held true to over a long period of time. The defendant's bright line rule to say that if you're not physically in the state working, then the Iowa Civil Rights Act doesn't apply to you would be both under-inclusive and over-inclusive. It would give, for instance, the protection of the Iowa Civil Rights Act to, let's say, a California employee hired in California by a California employer to work at a job in California, so long as, let's say, during her first 3 weeks of employment, she's doing training in Iowa and is sexually harassed here by her California boss. That would give her Iowa protection, even though the defendants had never been to Iowa and didn't have any connection with the state other than sending her here for training. On the other hand, the defendant's rule would exclude from the law's protection an Iowa citizen working for an Iowa employer who had no locations outside Iowa, so long as it assigned her to work from a customer's facility in Omaha for 3 days a week. That would effectively mean that she wasn't subject to the Iowa employment laws.
Counsel, if hypothetically we accept Deere's interpretation and hold that the Iowa Civil Rights Act does not apply to this case arising from conduct in China, how will that reduce the protections of all the Deere employees who work in Iowa at Ankeny and Davenport?
I need to correct one thing about Your Honor's premise, and that is we are not alleging conduct that occurred in China violated the Iowa Civil Rights Act. We are alleging conduct that occurred in Iowa violated the Iowa Civil Rights Act.
Well, weren't the decisions made either in China or Moline, Illinois?
Absolutely not.
Okay,
And
what
that's
happened?
another
What
problem.
happened in Iowa?
That's another problem with this case, because the facts that the defendant set forth are either genuinely disputed, or they're absolutely false, or they're
facts?
contravene.
Tell us about the acts that happened in Iowa that allegedly, I mean, we're talking about genuine, but, you know, but
Sure.
we're talking about summary judgment, so we don't need to do the credibility analysis, but just tell us what facts you have in this state that would support your claim.
The individual defendants, Haas and Zarnecki, are Iowa people. Contrary to what counsel told you,
Well, the mere fact
Zarnecki,
they're Iowa people.
Zarnecki worked out of Waterloo and lived in Waterloo. They made their decision, as far as the record reflects, they made their decision in Iowa to demote and expatriate Matthew. The decision was not, Matthew did not learn of that decision until they came to China to tell him. The whole thing about the China Compliance Committee, that was a recommendation. The documents state clearly it was a recommendation. All the contemporaneous emails show that that was a recommendation and that the decision was made by Zarnecki and Haas. And the defendants have given...
Wouldn't that decision be made at corporate offices in Moline?
Well, there is no evidence in the record beyond the plaintiff's evidence that the decision was made in Iowa, that the decision was made in Moline. The defendants don't contend the decision was made in Moline.
They're acknowledging that the decision, the discrete discriminatory employment action that they took was from Iowa. And where, that's what you're
No,
saying?
they're contending it was made in China.
Well, it's probably China and/or Moline, but where's the discrete discriminatory action in Iowa?
And see, this is another problem, is that I think when the laws were passed and when we think about it, we think about, okay, these people are getting together and having a meeting in some conference room. What city is it in? Then we'll know. These decisions were made by phone and by email. And so we have Zarnecki and Haas, along with some people in Moline, discussing by email what was going to happen to Matthew. I don't know whether or not Mr. Haas was on his email in Moline, whether he was on his email in Iowa, one of John Deere's many locations in Iowa, or whether he was in Germany at the time. He was by email and by telephone.
You know, the Iowa legislature expressly provided in the workers' compensation statute, it addressed Iowa employees who were performing work duties in other locations outside of the state. I don't see that in the Iowa Civil Rights Act. Doesn't that indicate the legislature knows how to extend the reach of the statute to protect employees elsewhere when it chooses, and they didn't here?
You're assuming that we're asking for extraterritorial application of the statute, which defendants are contending, and which we do not. Lensing and Rimmer specifically indicate that application of a statute is territorial in nature if it involves people, property, or effects of the decision in Iowa. And we have almost all of those things, and we only need one. So unless this court is prepared to overrule Lensing and Rimmer, which talks about the effects of the decision.
But the criminal statute in Rimmer expressly addressed conduct in and out of the state. And there we had the key piece of the fraud was defrauding the guy sitting in Davenport who answered the phone, and then they lied to him about the insurance claim.
He was actually defrauding the company in Wisconsin. But the fact that the statute, I thought it was a bit of a stretch to say the statute allowed for that. I thought the opinion, my reading of it, and I know you wrote it, so I'm going to probably bow to you, but the focus of the opinion before it got to the interpretation of the statute talked about what was constitutional and what was a territorial application of the statute. And the court in Rimmer held that it was a territorial application of the statute, even though this one little act happened over the phone, again, when one party was in Davenport and the other party was presumably in Illinois. That case involved a car crash that happened in Illinois that was set up and defrauded a Wisconsin insurance company. And the fact that this one phone call came to Iowa was enough to confer Iowa courts jurisdiction over that matter. And that was something that had to be proven beyond a reasonable doubt. Here, there is no way that under the facts, if we look at this from a summary judgment standpoint, which it is, the facts that are from the plaintiff's point of view or reasonably disputed clearly show that there is at the very least a jury question on whether or not acts violating the Iowa Civil Rights Act occurred in Iowa. And when that is the case, the Hammond case from 2005 says that if the merits issue is related to a jurisdictional issue, then it's up to the jury to decide that issue.
What provision in the Iowa Civil Rights Act provides for, what does it say about where venue should be? Which county in Iowa?
I don't believe it has a venue provision. I think it's just
But doesn't the venue provision refer to where the employer is headquartered or where the employment conduct occurred?
You might be right, Your Honor, but I don't recall a venue provision in the Iowa Civil Rights Act. And defendants didn't object to the venue. When we filed the Iowa Civil Rights complaint and said that Ankeny is Matthew's home unit, which was assigned to him by Deere and continued throughout his entire employment, including the time, or all the time that he was in China, they never questioned that the Iowa Civil Rights Act applied.
It just seems to me that if the way the venue provision reads, no county in Iowa would apply to this case arising from his employment in China, that's further indication that the statute was not intended to reach internationally or even across the river.
But that is not our contention.
What would happen a couple of questions. One, do you have an Illinois Civil Rights Act claim in this case? Or could you bring one?
I don't see how. I mean, his connection with Illinois is so tenuous. There is no other state in the nation and no other nation that has the kind of contacts with this litigation and with these parties than Iowa does.
Could you bring the same claims under Title VII, under the federal statute?
We could have brought claims under Title VII, but there was no indication at all that the defendants thought this was the wrong jurisdiction. They told the Iowa Civil Rights Commission that Haas and Sarnecki were the ones that made the decision, and they had their person from Matthew's home unit answer the complaint.
Procedurally, where are we if we hold that the Iowa Civil Rights Act does not apply to this case? Can you proceed with claims under the federal statutes?
Well, that is one thing that we did ask for in our prayer, is that if that happens, we would ask that the court not dismiss the case and remand it and allow for us to amend it to add a federal claim.
How do you, could you respond to Deere's argument that it would create a lot of angst and problems if international employers, now which laws govern people working in China, or for that matter, across the border in Minnesota, if you've got different provisions? You know, Iowa protects sexual orientation. Some of our neighboring states do not. How do you work that out?
You work it out just like a conflicts of law issue, because that's what it is. And we work those issues out every single day in all sorts of contexts. Defendants claim that their rule has been adopted by all these states. That's not true. The only state who has adopted this rule that says that you're only subject to the Civil Rights Act of the state unless you're working in that state is New Jersey. And even New Jersey has gone back on that several times and made exceptions without even saying why they've made exceptions. But almost every single other state has a variety of factors that they use to decide those questions. And most states don't have a particular provision in their act which says how or if it applies outside of the state. It's just not something that legislators think of. I have just a few minutes to sum up, and I think what I want to focus on is the fact that if this case was compared to the Lensing case, that involved a statute where an auto dealer had to have a bond and was not applied to people who bought the car in Arizona and had no connection to Iowa whatsoever. And these people in Arizona wanted to collect on the bond. May I have one more moment?
You may sum up.
Thank you. This would be like an Iowa auto dealer negotiated to sell a car to a citizen of Iowa in Des Moines, but the deal didn't become final till after the guy had gone to Arizona for the winter and the car was delivered to him in Arizona. And in that situation, as I think it is here, Iowa's interest in protecting its citizen and domiciliary right would be obvious. Thank you, Your Honors.
Ms. Fiedler, thank you as well. Mr. Harty, rebuttal?
Your Honors, let's clear up one thing right up front. I believe at least two of you asked for record citations to support the contention that the employment occurred in Iowa, that the decision was made in Iowa. You didn't receive one because there is no citation that supports that contention. If you look at the Appellee's brief, pages 29, 30, and 36, they allege on numerous occasions that the discriminatory decision was made in Iowa. There's no record cite on any of those pages because there are no facts in this record to support that. The only facts in this record, if you take everything that Mr. Jahnke alleges as true, the facts support the record that Mr. Zarnecki and Dr. Haas made the decision. We contend they didn't, but if they did, it was in Moline, Illinois, and it affected him in Harbin, China. And contrary to what you just heard, throughout this litigation, we've contended that the Iowa Civil Rights Act cannot apply in this instance. Moreover, there was never an allegation that Rich Zarnecki lived and worked in Waterloo. If you look at the appendix, page 55, the plaintiff himself alleged in his petition that Mr. Zarnecki lived in Scott County. There's absolutely no evidence that he worked anywhere other than the international headquarters in Moline. And certainly the fact that someone might have their bedroom on this side of the river does not mean that decisions that are made in the office should be subjected to Iowa law. We're not, again, this is not a conflicts of law question, I submit. It's not a jurisdiction question. It's not a forum nonconvenience question. Clearly, he had a remedy. It was Title VII, very clearly. This is a question about whether the Iowa legislature, when it passed this law, knowing that for 100 years, this court has said, if you want this law to apply outside the bounds of this state, you need to clearly state it. They did not. And moreover, again, this statute has been amended over 30 times. And most recently, with the Equal Pay Act 216A, again, we cite in our briefing, even in that newest portion of the statute, it refers to employment in this state. After the Supreme Court's decision in the Aramco case, where it held that Title VII did not apply to Saudi Arabia, the federal legislatures modified the act. This Iowa legislature takes note of what happens. You'll note that after the Lilly Ledbetter law was passed in response to a Supreme Court decision that the federal legislators did not like, they modified their law. Our state legislature followed suit shortly thereafter in enacting Iowa Code Section 216-6A. The statute was drafted to apply to Iowa. The legislature has amended it numerous times and has never, as referred to, never cleaned it up, I submit, because there's nothing to clean up. I'm going to close by citing references in the Runyon versus Kubota case, which was cited by the Appellee a number of times, but it supports the appellant's position in this case. In that case, this court applied the Iowa Wage Payment Collection Act to labor that occurred in this state. And in that decision, the court said, although our legislature may have a strong interest to enact a wage dispute law to protect non-residents when they cross our border to perform work in Iowa, it would have no interest in protecting non-residents in those instances where they perform work outside. And then finally, the court closed in the concurrence by stating that we have no business extending the protections of our law in favor of one non-resident against another non-resident involving disputes occurring outside Iowa. We submit, Your Honors, that in this case, the legislature would be shocked at the outcome that the appellee proposes, and that this court, with the guidance of the statutory language, has no business extending the Iowa Civil Rights Act to a workplace in China. Thank you, Your Honors.
Mr. Harty, thank you as well. Ms. Fiedler, thank you again. The case of Jahnke versus Deere and Company is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.